Alrighty, good afternoon, everyone. So this is just a reminder that this hearing is being recorded and transcribed. We also ask that you remain muted throughout the duration of the hearing unless you're making public comment. And we also ask that you please state your name for the record before making public comment. And with that, I'll hand it over to Carrie Embry.
Thanks, Miles. Good afternoon, everyone, and welcome to the Office for Consumer Health Assistance hearing for adoption of proposed amendment to Nevada Administrative Code 439B. And my name is Carrie Embry. I'm the Governor's Consumer Health Advocate with the Office for Consumer Health Assistance, also known as OCHA. The hearing to adopt proposed regulation R101-19 will now begin. Agenda item number 1, introduction to the hearing process. This is a hearing for the purpose of receiving comments. With this in mind, there will be no discussion, questions, and answers. The purpose of this meeting is to receive comments from all interested persons regarding the amendment of regulation that pertain to Chapter 439B of the Nevada Administrative Code relating to disputes between third-party insurers and out-of-network providers over payment of medically necessary emergency services in LCB File number R101-19.
President, most trusted business executive.
Authority NRS 439B.754, NRS 439B.757, and NRS 439B.760. You are welcome to email questions to OCHA, and I'll give you that email address. It's cha@govcha.nv.gov. That is CHA@govcha.nv.gov. Agenda item number 2 is public comment. If you would like to make a comment, you can raise your hand in Teams, and this can be found under reactions at the top of the screen. I believe Stacy, you have a question. Would you go ahead and give your first and last name and the organization you're with?
Hi, my name is Stacy Sasso. I'm with the Health Services Coalition. We do want to thank you for your time today regarding the revised proposed regulations. The Health Services Coalition represents 25 employer and union-sponsored self-funded plans in Southern Nevada, including Culinary Health Fund, Teamsters, Boyd Gaming, and numerous construction trades and public safety groups, representing about 280,000 lives. We reviewed the proposed revisions for 439B, and we do have a few concerns that we just wanted to bring to your attention today. It appears the intent of Section 19, subsection 2, is to provide information to help prepare the report that's noted in subsection 3. And since subsection 1 seems like it can accomplish the reporting of subsection 3, we're failing to see why subsection 2 is necessary. What additional information does the department expect to gain from providers and third parties to prepare the report defined in subsection 3 that the department cannot get in from the arbitrators in subsection 1? We would ask that subsection 2 of section 19 be removed in its entirety. In addition, section 5, subsection 3, the edit to 120 days to withdraw participation of a plan is workable and appreciated by our plans. We would, however, ask that D, the reason for requesting to withdraw the election, be struck from regulations. Finally, in section 6, subsection 2, We're reviewing the ability of our plans to provide requested information in a timely manner. Many of our plans are complying with the Federal No Surprises Act, and this addition may be additional burden to the individual self-funded plans. We would appreciate the removal of this requirement. Again, we do appreciate your time and we look forward to working with you on these regulations.
Thank you, Stacy. Any other public comments? Okay, moving on to the next agenda item, number 3. This is the Office for Consumer Health Assistance hearing for adoption of proposed amendments to Nevada Administrative Code, Chapter 439B, relating to disputes between third-party insurers and out-of-network providers over payment of medically necessary emergency services. An LCB file number R101-19, authority NRS 439B.754, NRS 439B.757, and NRS 439B.760. There are no substantial changes or revisions to the proposed regulation. LCB file number R101-19, dated September 9th, 2021. Existing law requires a third-party insurer and an out-of-network provider of healthcare that have a dispute regarding the payment for medically necessary emergency services rendered to a covered person to participate in arbitration to resolve the dispute. If such a dispute arises, existing law requires the out-of-network provider to request a list of 5 randomly selected arbitrators from an entity authorized by regulations of the Department of Health and Human Services to provide such arbitration. This is NRS 439B.754. For a dispute over a claim of less than $5,000, Section 2 of this regulation requires the request to be submitted to the department. Section 2 also prescribes the required contents of the request, provides for the review and approval of the request by the department, and requires the department to provide the out-of-network provider and third party with a written list of 5 randomly selected employees of the state who are qualified to arbitrate the dispute and who are determined not to have a conflict of interest. Section 3 of this regulation provides for the selection of an arbitrator and prescribes the procedure for the arbitration. For a dispute about a claim in the amount of $5,000 or more, Section 4 of this regulation requires the out-of-network provider to request a list of 5 randomly selected arbitrators from the American Arbitration Association or GIN. Existing law authorizes an entity or organization not otherwise subject to provisions of law governing the resolution of disputes between a third-party insurer and an out-of-network provider of healthcare over payment for medically necessary emergency services to elect to have those provisions to apply to the entity or organization. Existing law requires the director to adopt regulations governing such an election. This is NRS 439B.757. Section 5 of this regulation prescribes the procedure for making and withdrawing such an election. Existing law requires the department to compile a report which consists of certain information concerning the resolution of disputes regarding the payment of medically necessary emergency services. Existing law requires a provider of healthcare or a third party to provide to the department any information requested by the department to complete that report. NRS 439B.760. Section 6 of this regulation requires a third party that provides coverage to residents of this state and a provider of healthcare who provides medically necessary emergency medical services in this state to annually submit to the department certain information for the purpose of compiling that report. Agenda item number 4, public comment. Again, if you would like to make a comment, raise your hand in Teams, and that can be found under the reactions at the top of the screen. And please state your first and last name and your organization.
Harry, there's a hand raised.
Jack?
Yes, can you hear me?
Yep, please go
Yeah.
ahead.
Yeah, hi, name is Jack Kim. I'm with the Nevada Association of Health Plans, and we did provide some written comments. Hope to receive them on a timely basis. But we have a couple comments, not specifically about the details of the regs, but I think as our health plans have been working through the surprise billing in Nevada, they have some suggestions which we think would be helpful as this process continues. First two comments are really directed towards claims under 5,000. One of the things we've noticed as arbitrators are making their decisions, we're not getting a lot of detail on why the decisions are being made. We think it would be helpful for the health plans and the providers to get a rationale of what the decisions are and the reasoning behind it. We think this would be helpful as there's additional type of additional arbitrations, and it'll help hopefully make the process smoother for both parties. And the second piece on the 5,000 and under is that often when these arbitrations going on, some of our health plans have noticed that we don't get a lot of information that the providers are disclosing to the arbitrators. We think it would be helpful to have that information disclosed to the third parties. We think this will also help for future arbitrations. It may lead to quicker decisions from both parties. And the last piece is really related to any of the arbitrations, especially the ones where the carriers are being asked to certify that a claim is subject to the arbitration rules. The providers, if they submit the arbitrations, often then OSHA sends it to the carriers and asks them for the information. And we often have to figure out if some of these parties are actually subject to the Nevada surprise bill. In one case, one of our carriers indicated of the 900 requests they've gotten, 200 of them were outside the scope. There was just a funded, they hadn't elected. And so that's added a lot of burden on both OSHA and the carriers. Oftentimes the carriers are asked to provide documents that support that these are versus self-funded plans. In some states where we have similar requirements, all that's been required from the carriers is a representation that these are versus self-funded plans. That's enough. Our suggestion would be that the providers do some sort of, they determine whether these are even subject to the Nevada surprise billing before they submit to OSHA. That way, it actually would reduce the amount of claims or arbitration that OSHA would have to process. And then in the event that some of them are still questioned, the carriers can also just indicate, through representation that, hey, this is an ERISA self-funded claim, and it's outside the scope of this process. I'd be glad to answer any questions if you have it.
Oh,
Karen? Go ahead, please. Karen, I can see you have your hand up, but it looks like you're on mute.
Thank you. Can you hear me?
Yes.
Sorry, you'd think at this stage we'd all be a little faster on the draw, so thanks for your patience. I submitted some comments, but I wanted to follow up. My name is Karen Massey. I work with Northern Nevada Emergency Physicians in Reno, Nevada. I also work with the Medical Group Management Association, so have a perspective across practices. And I agree. I think one of the challenges we have, and I put this in my comments, was providers being able to determine if they're in the state process or the federal process. The federal law did contemplate this and identified some codes that they have encouraged insurers to pass at the time of claim. That would be a tremendous help to us. There's specifically N858 for state and N895 for federal. And I don't know if there are barriers, but I think considering that as part of the state legislation might expedite that and reduce the workload for providers, insurers, and certainly OSHA. So I just wanted to share that. The rest of my comments are submitted for the record. Thank you.
Other requests to make comments? So with that, this concludes the Office for Consumer Health Assistance hearing for adoption of proposed amendments to Nevada Administrative Code, Chapter 439B, relating to disputes between third-party insurers and out-of-network providers over payment of medically necessary emergency services in LCB file number R101-19. Authority NRS 439B.754, NRS 439B.757, and NRS 439B.760. I want to let all of you know that previous workshops regarding LCB file number R101-19, this hearing today and related documents can be found on Aging and Disability Services Division website, which is at adsd.nv.gov. Again, that is adsd.nv.gov. And thank you for taking the time to attend this hearing today. I appreciate all of your comments and your continued support through this process. And this hearing is now adjourned.